Welcome to Let's Talk TCI Real Estate, a show that is geared towards educating on all things real estate in the Turks and Caicos Islands. As usual, I always invite you to like and share the page. And of course, if you have a comment, put it in the comment section and let us know where you are listening in from. I am excited about our show today. We will be speaking about probate, the probation process, and the administration process of real estate in the Turks and Caicos Island. And I am just delighted to share this information with you. So I just want to say that normally we would have been in a different setting, but today we are actually in studio, and I am in studio with my guest in the presence of Miss Devonna Duveau. She is a young professional and an attorney at law, and I am so excited that she's able to come and share her knowledge with us on this topic. So without any further delay, I am going to ask her to introduce herself. Miss Devonna, go ahead.
Well, thank you, Bernica, for having me. I'm excited to be here with you today. And good evening, Turks and Caicos. My name is Devonna Duveau, and like Bernica said, I'm an attorney at law practicing with Stanbrook Prudo.
Well, thank you so much for coming with us. So, of course, this is a subject that I've had come up from time to time with customers of mine who doesn't really understand the process and doesn't know when there is a need for probation or administration. So I'm delighted that you are able to come and share your knowledge with us.
Happy to be here.
So for the listening audience, we're going to start with the basics, and then we're going to get more deeper into the questions.
Okay.
And therefore, I would like for you to just start by explaining to us what is the difference between, probate and administrate, when you're in terms of property in the Turks and Caicos Islands.
All right. So probate and administration, the difference mainly between the two is that probate and the process of applying for a grant of probate is the process that you would take when there was a will. So if a person died and they left a will, then you would go through the process of getting a grant of probate in order to be able to manage that estate that they left. And the administration process is what you would do when there was no will left by the person. So if someone died without any will or instructions, then you would go through the process of applying for grants of letters of administration to the court.
Okay. So one basically, like you said, one is with a will and one is without a will.
Pretty much.
Okay. So take us a little bit through the process. It doesn't have to be anything, anything very difficult. Just a simple idea of we'll start with the probate process. Mm-hmm. How does that work? Like, for example, what is required for it? Or like what time frame is expected for completion? These are some of the things they would want to know.
Okay, so both processes are pretty similar. The probate process, what is required, you would go to an attorney. If you have the will, that would be a great place to start. So you'd get a copy or the original will and you take that to the attorney. Before I say the process, the person who is entitled to apply for the grant of probate would be the person who is appointed as executor in the will. And so once this person is identified, you would go to the attorney and then they would work with you in drafting the documents. And this would include the petition, which would have information on the person who died, so the date of death and the place of death. It would also include information on the estate, so what all was in the estate. It would include information on the survivors, so who they were survived by, whether children or a spouse, and also just the fact that they left a will and that you, being the applicant, was the appointed executor. So that's the petition. And then you would have to also provide an inventory, so just giving information on all of the assets as you know of that was left in the estate. You would need a solemn declaration, which is you declaring that you will faithfully give an account for the property in the estate and that you would execute and manage according to the will and the wishes of the deceased. And I believe you also would need an affidavit, which again would give information on the person who died and information on, evidence for attaching the will, so exhibiting any other documents that would be necessary for the court. And there's a fee for the probate and administration, and that would depend on the value of the estate. So that's what you need typically for probate. And The time frame you asked. So the
Yes.
time frame for both the grant of probate and grant of administration, it would widely depend on how comprehensive the application is. So if you included all of the relevant information and if your paperwork is all there and the court is satisfied that the application is thorough, then it would decrease the amount of time that it takes for the application to be processed. But it also depends on the court schedule and the capacity of the court at the time. And so the application can take about sometimes 6 months. It can take as long as a year. It just depends on what's happening in the court. It depends on what's happening with the application and the complexity of the application and the estate.
Okay. So you had said that, because you started off talking about probate, and you mentioned that the person who's going to deal with the probation as the person who has rights to execute.
Yes.
Right. Is this the same in regards to the administration process?
No. The person who is entitled to apply for letters of administration, this depends on, it depends on who survived the person, the deceased. So with probate, like I said, the will would appoint a person. If you draft a will, you would typically appoint the person that you wish to execute on your estate after you've deceased, after you've died. And it's that person who will apply for grant of probate. But without a will, with letters of administration, it depends. There's an order of entitlement. So there is a person who is first given entitlement to apply. That typically would be the husband or wife, if there was a husband or wife left, or the children, or if there were no children, then the parents. If there are no parents, then the siblings. And so there's an order of entitlement. And so the person entitled to apply would just be based on who was survived.
Okay, so there is a packing order when it comes to administration of rights. And what happens, just throwing it out there, if the person who is in that first packing order does not want to administrate, can that person in the second line automatically deal with the administration, or would they have to get consent?
Right. If the person who has first entitlement does not wish to apply for the administration, then they would have to renounce their entitlement. So there's a document that they would have to sign and execute, just renouncing their entitlement to applying for grant of letters of administration. And the person who now is going to apply would present this with their application to the court.
Okay, so I just want to ask, because every time you say something, I have another question. So what if there is a person who has, I guess we have a lot of relatives who are not on island, who are living, we're connected to the Bahamas. I'm just using a reference, an example. And it's just that person is probably not in their sound mind, or that person just doesn't want to deal with it because of the person. Can that be, can you override that, or you still have to get that consent from them that they do not wish to administrate?
Do you mean, I'm just trying to understand the question. Do you mean if you can override a person who does not have capacity?
Right.
Without having to get the renunciation?
Right.
In that situation, the court would still need some sort of evidence, to show either that there is firstly a person in higher entitlement to you, and you would have to show that this person lacks capacity so they can execute or grant a power of attorney so that someone can act on their behalf. This is the person who doesn't have the capacity, that is. So they have a power of attorney. That power of attorney can be the one to sign the renunciation to allow for someone else to apply for the administration.
For the administration. Okay.
Did that sufficiently answer?
Yes, that's fine. Thanks. And in the case that there is more than one owner of a property, right? And so more than one owner have deceased in terms of administration, right? So a property is owned by two persons, and it's not joint proprietors, it's in common. So both persons have to administrate.
Right.
Can each family have their own attorney to do the administration process?
Yes. So just to make sure that I understand the question, if A and B own a property together but not as joint proprietors, when they both die, if their family can have two different attorneys.
Correct.
Absolutely. Because there's two different applications, like you said. So if it's not joint proprietors and you own a property as proprietors in common, even though you own it together, your share is separate, and
Correct.
so your share would pass to each of your estate.
Right.
And so your family who is submitting this application for administration, they can hire two different attorneys because it's dealing with two separate, portions of the property.
Okay. I mean, I specifically asked that because I know sometimes we have a lot of generational properties here on island, and most times our forefathers would have left properties to more than one family member. And sometimes in dealing with properties, there may be conflict among other family members when it comes to the administration process. So it's really good to know that each particular family can hire their own attorney to represent their own interests to get the administration process completed.
Yeah, and sometimes that might actually be beneficial to have different attorneys because it just depends on what the intentions are and how smoothly the transaction would go. There might be some conflict that arises, so it might even be beneficial to have different attorneys.
Right. Okay, I mean, I'm glad to know that. Yeah. Good. So let me so we were talking about the will and the probate process. Can you explain the importance of having a will? In the Turks and Caicos Islands, I think this is a very good question. So explain to us, why is it so important to have a will?
It is imperative to have a will, like you said, especially in the Turks and Caicos where we have generational property that passes from one person to the other. But it is extremely important to have a will, and having a will has tremendous benefits. So, for example, if you have a will, you can direct the distribution of your property. You can control how your assets are distributed. You can decide who gets what and what portion they get, whatever assets or property. If you don't have a will, the property that you leave behind is administered and dealt with under the laws of intestacy. So the laws would dictate who gets what, out of your property. And there is no 50% or 60%, this person 40%, 20%. There's no, division of that apart from either if you leave a husband or wife, they would get a certain portion. And it also depends on who else you leave. So if you leave a husband and wife along with children, it would be split up in one way. If you leave a husband and wife with no children but parents, it would be split in another way. If you leave no husband and wife, no children, no parents, then the next in line would be your siblings of the whole blood and their children, and then siblings of the half blood. And so it gets tedious. There's a flow and an order. But if you have a will, you can decide, I don't like this sister, and so I don't want her to get anything. I'm going to give it to this person. So you can really decide who gets what. You can also do things like appoint guardians for your minor children because things happen and no one, you can't really predict when something is going to happen. But if you have a will in place, you can appoint a guardian to your minor children and have that in place, before you, or you decide before you die who can have the authority to rule or to take your children. You can also do things like donate to charity. Some people actually want to donate their assets or their money to charity after they've died, but without a will that would not be possible because the laws of intestacy does not allow for that. And so you can do lots of things with a will, and so it is tremendously important to have a will to avoid things like family arguments and fallouts because this person said that their mother left certain property to them, but the other person thinks the same. And so it can avoid a lot of issues after you've died if you have a will.
Okay. It's so interesting that you said, and even in terms of, your younger children, you left a will. So I'm just thinking, so a husband and a wife is not together and they leave a will for their kids for someone else to be the guardians of their kids, then the court actually has to obey the will.
Yeah, in most cases, yes.
Okay.
Obviously, it depends on the circumstances. Without a will, it is entirely, most times, up to the court. But if you do have a will, you can appoint. And also, sometimes, if one parent had sole custody, and it was for a certain reason why the other parent did not have custody, then you want to make provisions for, who's going to get custody or guardianship over your minor children in the will.
Right. Okay. Talking about court again, it just brought me back just to make sure, reiterating, we were talking about administration. Does that process also go through the courts? I couldn't remember the response to that one.
Yes. So the process of administration goes through the courts as well. And it's similar to the process of probate. You need similar documents. You need the petition, the affidavit, an inventory of the estate. You need the declaration again, I believe, and then you need consent. So I spoke about the renunciation. So if there's someone related and who has a higher level of entitlement, they have to renounce their entitlement. But if there are people who have the same level of entitlement, so if there are 4 siblings, no parents, no spouse, no children, but there are 4 siblings and only one of those siblings will be presenting the application, then the other 3 would have to consent. And so you have the consent, the petition, and all of those things, similar to the probate process, and it also goes to the court.
Okay. So just going back to wills now. Do you need an attorney actually to help you to draw up a will?
Technically, you don't need an attorney. Technically, there's nothing that says specifically that a will, drafted without an attorney would not be valid, but it is highly recommended to have an attorney to help you with drafting your will, just because the attorney would be able to ensure that the will is properly valid. There are certain formalities that the will has to follow. You have to ensure that you have the right capacity to execute a will, and the attorney would be able to follow all those formalities and the rules to make sure that your will is valid. Because there are cases that if you draft your own will, not knowing what the proper procedure or the proper rules are for the will being valid, if you execute that and then you die, and then it comes to find out that it wasn't actually drafted according to the rules or according to the proper formalities, then your estate would still be taken to be, or you would still be taken to have died intestate. And your estate would still be dealt with according to the rules of intestacy, as if there was no will.
And the court is going to determine if your will, if your will conforms to the rules of how a will is supposed to be set out.
Yeah, so in the process, because if there was a will and you believe that the will was validly executed and is valid and enforceable, then that would have to be presented to the court with the probate application. And if the court, in their reviewing of the application and the will, finds that it's not valid, maybe because it wasn't executed in the presence of 2 people or whatever the case might be, then they would not grant probate and it would have to go through the administration process instead.
Okay. So let me ask you something. Would all wills have to be registered in order to be enforceable?
No. So the will would not have to be registered, but again, it has to meet the certain formalities as dictated by the legislation. It does not have to be registered, but just has to be valid.
Okay. So I've heard attorneys continue to talk about what's the thing? Wills or grants being sealed or resealed. Can you explain that process in terms of wills, probate? How does that all fit in together?
Okay. Well, when you apply and are issued with a grant of probate or grant of letters of administration, that allows you to administer on the property or manage the property. And that grant only would apply to the country in which it was issued. So if someone died in Turks and Caicos and they have property here, and you go through that process with the Turks and Caicos Island Supreme Court and they issue a grant of probate or grant of administration, then that only gives you authority to execute or to manage the property in Turks and Caicos. Right. But if this person had property in other countries, you would typically have to either apply for grants of probate or administration again in that country, or what you can instead do is apply for the grant to be resealed. And so if you make that application and the grant is resealed, then that resealed grant gives you the authority to act on the estate in that other country.
Okay, so the resealed grant, let me just take it one step at a time. So someone from Canada owns property in Turks and Caicos, but they have left a will and it's already gone through all the process. So now their relative wants to sell. So even though that the probate process was already done over there, now to come, they have to reseal it here in the Turks and Caicos?
They would have to get it resealed, yeah.
Okay. So how is that reseal process? Does that take as long as a regular process, like the regular probate process here? Or is it a shorter period of time, seeing that it's only a reseal?
It typically would be shorter, but it also depends on the country and the rules of that country, because the process actually is quite similar, and the documents that you need for the grant to be resealed is sort of similar to what you need for the grant of probate. But because you've already gone through that process, it should be simpler and easier and quicker to get all of that information and to submit it. But it should be quicker.
Is there any insurance bond or anything that's required when you're doing this process?
You do need an administration bond for both the probate and the administration. And this bond would be where you declare that you are going to faithfully, follow the legislation and how you distribute the property, or faithfully comply with the will and the wishes in the will with how you manage the estate. And so you would have to sign, and most times get a surety to also sign along with you, to sign an administration bond, that if you don't do that, or if you don't provide the inventory to the court when they request it, or any other information the court requests, then you would have to pay a bond.
Okay, and the bond is dictated by the court?
Yes.
Okay, so an administration bond, not really an insurance bond.
Right.
Okay. I'm just asking because I'm hearing all of these terminology, and it's just like it's just trying to really understand the process, because you speak to different people and you speak to customers, and they're saying, well, attorneys are asking for this, and that's why there's like they're asking for an insurance bond, and I'm like, I have no idea what they're asking you for, and so that's why it's really good to have this conversation to clarify it, so it's more of an administration bond and not an insurance bond.
Right.
Okay. So I just want to pause just for a minute just to say, of course, if you have any comments, please leave it in the comment section of the live feed. We would love to hear from you. Let us know where you're listening in from. Let us know what you are receiving from this conversation. Any ahas in the conversation, any questions you may have, please put it in the chat below, and we will do our best to answer those questions in the comment section after the show has finished. So, okay, so we're getting ready to wrap it up. Well, I just have 2 more questions for you. So for a person who may have inherited a property, and they that relative may have left a will, would that person be able to sell without going through the probate process, or they must go through that process first?
They would have to go through the probate process. Although the will is technically the document that gives the authority to the executor to act, to manage the estate, it is the grant of probate that proves that authority. And so selling any property, the land registry would want to see the certificate, this grant of probate. And so in practice, you would have to go through the grant of probate in order to sell. But again, it is the executor who would distribute the property and sell whatever property, and, distribute it according to the will. So not the relative, who inherited, it's the executor.
Well, I thought that I think that the conversation was really good today. I think I learned a lot, and I just want to say to you, thank you definitely for coming on the show.
You're welcome.
But is there anything that you feel that we did not speak about that we could perhaps, you can perhaps share with the listening audience about the whole process of wills and administration, or even what can you offer to someone who's looking to go through the process? What advice would you give to them?
The advice that I would give to someone looking to go through this process would be to act quickly, first of all. There is, in the ordinance, there you are allowed 6 months in order to apply for administration or probate after the person died. And so that's not really a lot of time if you think about it, especially if you're a relative. You're first of all grieving, you're dealing with the funeral and all of that, and then you might forget. But if you just keep it in the back of your mind, or keep it in mind to act quickly, that would be beneficial. But if you don't, if you pass that 6 months, you can still submit the application. You just have to give extra evidence and reasons for delay. Like why did you delay in submitting the application? So that's one, act quickly. And secondly, I would say to start compiling any evidence, any documents that you can find. That might be identification documents. You might have to submit birth certificates or death certificates. Well, you will need the death certificate of the deceased, but you might have to submit birth certificates for relatives or for yourself, or other identification documents. You would have to submit documents relating to the ownership of any property, so land registers. If they own shares, then share certificates. And so the sooner you can compile those documents, the sooner the process can get started and can progress. I would also say to speak with an attorney. This will, most times, it's already a difficult period in your life or in people's lives. And so if you speak with an attorney, they'd be able to hold your hand and assist you in this process tell you all you need, give you advice and just help you to get the process moving along. And lastly, I would say to have a will executed. Yes, to prepare a will or to speak with an attorney again to help you with executing your will, so you would not be in the position where your family members end up arguing over your estate after you've died.
I think that's really good advice.
Thank you.
While you were speaking, I was just listening to you talking about the 6 months time frame. And a lot of times when people pass away, we notice that if you're reading the Gazette, that people reply right away.
Yeah.
And you've heard comments as to, oh, that person isn't dead in the ground properly, and they're already applying. But basically, they are trying to comply within
to beat that time.
the process, the time.
And you also see where people died years ago, and the application is just being progressed. And acting quickly not only complies with the ordinance, but it helps things to go smoother, because the longer you take, people might have died, in between that. Beneficiaries or the executor, like you mentioned, might have died in between that, making the process take longer. Or you might just forget. You might forget which bank account this person had or which bank they used. You might forget where the property is or what the property, So it just helps if you act quicker. You would remember and retain more information. You'd be able to help the application to progress more smoothly.
Yeah, I think that's really good.
Yeah.
So I'm just saying, can you please share your information just in case there is someone out there who is looking to administrate or go through that probate process? Please share your information.
So again, my name is Davanya DeVoe, and you can contact me at my email address, which is davanya@spcaribbean.com. So that's DAVANYA @spcaribbean.com. And the website of our firm is www.spcaribbean.com. So you can find our information there, or you can just send me an email to ask any questions that you would have.
Great. So thank you once again for accepting the invitation.
You're welcome.
To be a guest.
You're welcome.
And
Thank you for having me.
Yes, and like I've said before, it is so it's so important to get this information out to the public, and it's so important to have this information where someone can go and review it for the first and the second and the third time, because sometimes you hear about something and you don't get it right away.
Yeah,
but
that's true.
But for me, sometimes I repeat the shows over again. It's like, okay, I didn't catch that the first time, but then now I have the information for a second time as your reference.
Yeah.
So I really appreciate you coming on the show.
No problem.
And for the listening audience, always let me know if there is a topic of concern that you are interested in knowing about, and I'll try my best to find a professional like Mr. Vanya to come in and share their knowledge with us so we can learn and grow together. So, as usual, I would say to you, be blessed and stay safe. Have a great, great afternoon. Thank you. The views, thoughts, and opinions expressed on this show belong solely to Let's Talk TCI Real Estate and not that of Keller Williams TCI or any of its affiliates. Any action you take upon the information provided on this show is strictly at your own risk, and Let's Talk TCI Real Estate guest or host will not be liable for any losses and damages in connection with the use of the material. I am not an investment advisor, broker, or dealer.